Welcome to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. I'm Frank DeVito, Senior Counsel and Director of Content here at Napa Legal. So we have an exciting special episode here where we're joined by our esteemed guest, Chris Schandevel. Chris is Senior Counsel at the Alliance Defending Freedom. He was previously an Assistant Attorney General in the Virginia AG's office working in appeals. And for those interested in writing, particularly legal writing, he's one of the best follows on all of LinkedIn. And I don't say that lightly or to be nice. I think there's a lot of writing about writing that is really bad, and I don't follow most of it, but Chris is really one of the best. So if you're interested in writing tips, being a better writer, great follow on LinkedIn, highly recommended. Um, so Chris seems to be involved with nearly every interesting religious liberty case that's currently pending at the Supreme Court. But we're here today to talk about the St. Isidore Catholic Virtual School case. So Chris, first of all, thank you so much for taking the time to join me and have this discussion.
Sure thing. I'm really excited to get to have this conversation. I appreciate the warm intro, especially the shout out to my LinkedIn dabblings. I have a lot of fun over there, but I have even more fun in my day job, which is what we're here to talk about today.
Yeah, so let's start with that. Before we dive into the details of the case, can you just tell us a little bit about yourself generally, your legal work, and particularly how you came to be involved in this St. Isidore case?
Sure, absolutely. So I have been with Alliance Defending Freedom for 6 years now. Before that, like you said, I was in the Virginia AG's office litigating criminal appeals. I did that for 5 years. I went to law school thinking that my dream job was to litigate religious freedom cases and to really use the talents, the gifts, the abilities, and the interests that God had given me to do work that would be pleasing to Him, to use my talents in a way that was would advance the spread of the gospel. And so that's what I knew that I wanted to do, and went into law school with that being the goal. Now you get to law school and you realize just about everyone there wants to do constitutional law, right? And there aren't a million opportunities out there once you get into practice. So I ended up being at the state AG's office doing criminal appeals. Got a lot of really good experience in those 5 years. I argued something like 75 appeals in 5 years, which is like unheard of if you go like a private sector route. So the benefit of government work is the reward for good work is more work. That's also the downside of government work. But I got a lot of really good experience. And then about 5 years into that, I felt the urge to pursue something else and felt that calling on my heart from God to join an organization like ADF. And it just so happened that I got an email around that time letting me know that they were hiring. ADF's appellate team specifically was hiring, and I had met the John Bursch, who leads the appellate team, former Michigan Solicitor General. I met him a couple years prior, and he and I really hit it off, connected over our shared love of Century School Book and other nerdy legal writing things that I talk about on LinkedIn, like you said. And so God really just opened the door in a very clear and explicit way for me to come here. And I've been here ever since. I came in thinking it was the dream job. It has been the dream job every single day, getting to wake up and work on interesting cases with some of the brightest minds in the legal profession, but also people who are just men and women of faith and committed to doing the best work they possibly can and sharing a common belief in Christ and what God has called us to do. So I was really excited to get to work on this case, specifically the Oklahoma Statewide Charter School Board versus Drummond case. I heard about this case when we first were picking it up a couple years ago, when the Oklahoma Attorney General was suing the government entity, that statewide entity that ended up becoming our client, the Oklahoma Statewide Charter School Board, because that statewide entity had gotten an application from a Catholic charter school that says we want to run a charter school. We want to have a charter school and receive funding to do that, to serve kids throughout the state. It was going to be a virtual charter school. And that statewide entity said, asked for an opinion from the Attorney General, got an opinion that said, yes, this is constitutional. And not only that, but this private group, has free exercise rights from the federal Constitution, so you should allow them to run a charter school. Unfortunately, after they approved, or I guess soon before they approved the charter school, a new Attorney General took over, Gittner Drummond, reversed course and said, no, you're actually not allowed to approve a religious charter school. So he filed a lawsuit that we litigated, ADF litigated in the state Supreme Court, which is when I first heard about the case. But then I didn't actually get involved in it until the Oklahoma Supreme Court ruled against our clients, held that under the state constitution it was unconstitutional to allow a religious charter school, and we decided to appeal that decision up to the U.S. Supreme Court. So that's when I got to step in and help to work on the cert petition that was ultimately granted.
Excellent. Now, yeah, I feel there are so many interesting religious liberty cases going on this term, as you well know, but this one particularly is, I'm excited about the potential outcome and about the facts and the continued line of religious liberty cases that this will hopefully be the culmination of. But I also I've been involved. I think I wrote a piece on it before the lawsuit was even filed. Like I was following this from the beginning when SCOTUS granted cert. I had like friends texting me, and so we've been watching this for a long time at Napa Legal. So
excellent. So you've been following it more closely and longer than I have been, if we're being honest here, because it didn't really land squarely on my radar until we got the decision from the Oklahoma Supreme Court, and I found out that it was a case I was going to get to help with taking up to the Supreme Court.
Well, if I had heard about it a little earlier, I'm sure you know much more about it than I do at this point. So I want to dive into some of the issues here. So
sure.
If I understand correctly, especially from oral argument and from my familiarity with the briefs, it seems there are basically three questions going on here. There's whether this charter school status makes the school a state actor, right? And then there's an establishment clause question and there's a free exercise question. Is that right?
Yeah, and that first question is actually kind of a two-part question. So basically the question is this charter school somehow an entity that does not have constitutional rights? So is it either part of the government by being a government entity, or is it still a private entity that's engaged in state action when it's educating its students? So if it's engaged in state action when educating its students, then the argument is, well, it doesn't have any free exercise rights when it's engaging in state action. So yeah, so kind of two sides of the same coin on that first question. And then, like you said, there's the Establishment Clause question and there's the free exercise question.
Okay. So then the first question on this state action / private entity, this is kind of a threshold question, right? Because if the charter school is either a state actor or some kind of a public entity, then it doesn't have free exercise rights, and the rest of this kind of evaporates. Is that right?
Right. That's the way that we've been viewing the case and the way the case has been litigated.
Okay, good. That's helpful background, because I know a lot, especially people who follow like First Amendment religious liberty stuff, that the state actor question is a little bit outside the normal wheelhouse of free exercise jurisprudence and reigning in the Establishment Clause. So happy to have that part clarified. And now let's dive into the First Amendment a little bit.
Sure.
So I want to talk a little bit about the Establishment Clause part before we jump into the free exercise precedent and where we think that's moving. So on the Establishment Clause side, I won't rant for too long. I tend to do this when the Establishment Clause comes up, right? So Congress shall make no law respecting an establishment of religion. We have to put aside, as much as I'd like not to, that this was meant to prohibit federal establishment because states did in fact establish religions at the time of the founding, right? But now it's incorporated and now it is a prohibition on establishing religion by a state government. Okay. So we put that aside.
Right.
My understanding is that establishment means something specific. It means establishing one particular religion or one particular denomination via state power and excluding others. I know that's a broad brush, but is that about right?
Yeah, we do think that is certainly the primary harm that the Establishment Clause was intended to avoid and to protect against. It's to protect against the government picking and choosing winners and losers when it comes to religion and saying, this religious belief, this denomination is going to get priority and even government support and coercion and compulsion, and to the exclusion of other religious beliefs and other religions. And so we saw the Establishment Clause enacted as a response to that occurring, the potential for that occurring at the federal level. And then we saw eventually a lot of the states disestablish their own churches, Virginia being one that kind of led the way on that for similar reasons. Now that being said, just to kind of strongman the other side's argument a little bit, that wasn't the sole concern, I don't think, that the founders were worried about. So in Virginia, for example, you had the attempt to pass a tax, this religious assessment that was supposed to be used to support Christian ministers. And that assessment, in theory, whoever was paying those taxes that were earmarked to support ministers, in theory, they were going to be given the opportunity to choose, well, I want my taxes to support my minister. But the objection to that wasn't that, you're picking one established church, because again, it was to support multiple. But one of the main objections was, well, you are coercing and compelling religious conduct. You are forcing me to pay a tithe, and perhaps I don't want to pay a tithe, or I don't want to pay this much of my money to support my church. So there is an element of coercion, even if it's coercion across the board. But what was at issue in Virginia in the early days of the founding was a specific tax that was earmarked specifically for one religious purpose, and so the result of that was it was the equivalent of forced tithing. However, if you look at the same members of the founding and what they supported when it came to government support for schools, the same founders who were very opposed to any sort of taxation to support Christian ministers fully supported public dollars going to support education that was religious in nature. So from the time of the founding, there was that clear distinction that was being drawn.
All right, that's really helpful. So following up, that's history. That's, I think, original meaning. I think we're on pretty solid ground that's the proper boundary somewhere in there of establishment. But so what is the current precedent on what establishment means, or is it clear? And then could this case help move the needle back toward an original meaning understanding of establishment?
Yes, as you know, there was a long time when the Establishment Clause precedent was not great if you believed in religion and the fact that religion can be exercised in the public square. So we had the what was called the Lemon Test, which was that three-part test that looked and asked whether the law that was issued had secular purposes, was the primary effect to advance or inhibit religion, did the law foster some sort of excessive, quote-unquote, excessive entanglement with religion. The problem with that test, as I'm sure you're well aware and your listeners probably are too, is that it allowed judges to really run roughshod over the public exercise or display of religion. And so all sorts of things were being banned that at the time of the founding would have had no constitutional problem whatsoever. So then we went through a couple decades of wondering whether the Lemon Test even really existed or applied anymore in the Establishment Clause context. It seemed as if the Supreme Court wasn't applying it or even citing it, but it hadn't expressly said that it was overruled or that it wasn't applying it any longer. But then we got a case back in 2019, the Bladensburg Cross case, in which the court said we're really looking to historical practices and understandings in the Establishment Clause context. We're no longer focused on this three-part lemon test. And then more recently in 2022, we had the Kennedy versus Bremerton case when the Supreme Court finally once and for all declared, we have long since abandoned the lemon test. And all of us practitioners out there said, well, nice of y'all to tell us. We appreciate that you finally made that clear. But now that we have that decision, that line from Kennedy, we know that the lemon test is no longer good law. So we are in a place where we're looking at historical practices and understandings. And since that is the clear test, what we also know based on the relevant history in this context, even in Espinoza, which I think was maybe back in 2018, it was decided several terms ago, no, 2020, so 5 years ago now, the Supreme Court looked at that history and in the majority opinion said, the founders have long since supported public funding of religious education. In fact, at the time of the founding, the early 1800s, all primary school education was private, and most of it was religious, and government supported and funded that religious education. So we know that the test is historical practice and understanding, and we know that based on the historical practice and understanding, there is no Establishment Clause problem when public dollars are flowing to religious schools, so long as there's no sort of coercion involved.
Right. Yeah, that makes sense. And when this case first started to generate interest, I forget where I published it, but I wrote a little essay on some of the background on this. And I think the history behind the whole public school funding and exclusion of religious schools is fascinating, because if I understand correctly, and I'm pretty sure I do, this whole idea of government funded schools having to be secular or non-religious it's such a wild anachronism, because I mean, the whole invention of a public school system was a very particular historical response to large-scale Catholic immigration and the emergence of private Catholic schools, and a lot of American Protestants kind of worrying that Catholic doctrine was proliferating through these schools. And so the public schools were kind of found, they weren't denominational, but I mean, they read the King James Bible, they prayed the Our Father, like this, that's what a public school kind of was in its origin, if I understand it correctly. So I think that kind of adds an interesting like backdrop to this whole case.
Yeah, definitely. And so they weren't non-religious,
Right.
but they would be considered non-sectarian as
Yes.
they used the term at the time. But we hear non-sectarian today and we think, oh, that just means non-religious. No,
Right.
when they said non-sectarian at the time, what they meant was non-Catholic.
Yeah.
So they could still have Christian practices and reading the King James Bible, et cetera, which was an offense to Catholics who didn't subscribe to the reading of the King James Bible. So they could still be very religious in the public schools, and no one seemed to have any issue with that. It was just like you said, as a response to Catholic schools popping up and really educating their students so well, which is
Yeah.
exactly what Saint Isidore is seeking to do here. So kind of some of the parallels between that history and what's happening in our case are really interesting to think about as well.
Yeah. Yeah, thanks for letting me diverge here and highlight that.
Sure.
So I want to now move into some of the free exercise clause jurisprudence, and maybe you'll help us paint a little bit of a picture of where this has gone the last 10 years or so, and where we think it's going. So obviously, probably everyone listening to this knows the free exercise clause, right? Congress shall make no law prohibiting the free exercise of religion. So it looks like over the last decade, at least in my view, we've been laying the groundwork to kind of recapture a proper free exercise clause jurisprudence, especially in some of these cases involving schools. And so we have, right, Trinity Lutheran, we have Espinoza, now we have Carson v. Macon, which I think is like the big one that's kind of maybe I'm oversimplifying, but kind of the predecessor to the St. Isidore case. So, and from my understanding, especially in Carson v. Macon and that decision, there's been kind of this growing rule that if a government is excluding a religious individual or organization from an otherwise generally available program, and that exclusion is not required by the Establishment Clause, then we probably have a free exercise violation. Is that more or less right?
Yeah, that's right. So if the sole reason for the exclusion is because the person or the group, the organization is religious, and that person, group, or organization is otherwise fully qualified for that government program, that government benefit, then yes, there is a free exercise clause interest that's being infringed, which then triggers strict scrutiny. So unless the government can show that it has a compelling interest, and that's least restrictive means, then that is going to be a free exercise clause violation. And what the court has said over and over again in those cases that you mentioned is that the government's saying, well, we get that this isn't an establishment clause violation if we were to do this, but we still have some anti-establishment interests that are stronger than what the Establishment Clause requires. And what the Supreme Court has said over and over again is that no, an intent to enforce the Establishment Clause more fiercely than the Constitution actually requires you to do so is not a justification for violating someone's right to exercise their religion. And so that was really the second question presented in this case is, assuming that St. Isidore is not part of the government and it's not engaged in state action, then that means that it's a private actor and it's engaged in religious exercise. So is it a violation of their free exercise rights to exclude them from this program that they're otherwise qualified to participate in, to receive government funds to run a charter school there in the state? Is it a violation of their free exercise rights to exclude them when the only interests being asserted are interests that go much further beyond what the Establishment Clause requires?
Yeah, that's a great summary. So then I guess my question, I want to hone in a little bit on like the differences between where Carson v. Macon left us and where an ideal ruling in your mind in St. Isidore would bring us. So
Sure.
I know obviously the facts are a little different. In Carson v. Macon, it was a voucher program, right? Or some kind of a tuition assistance program for rural
Yes.
people who couldn't make it to the public schools. They excluded religious schools from that, but the funding was indirect, right? It was like a voucher that goes to the parent, and then the parent can spend it at a religious school.
Well, so it's thought of as being indirect funding, but if you actually read the facts of the case in the briefing, the tuition was going directly from the government to the private schools themselves, to the religious schools themselves. But there was that element of parent choice that a parent had to say, we want to send our kids to this religious school, and that's what triggered them being eligible for this tuition funding if they didn't have a public school that was geographically close to them.
Okay, that's helpful. So then what in your mind, what distinguishes the facts, the legal principles, the opportunity here between Carson v. Macon and St. Isidore?
Yeah, I mean, so I mean, our position has been that the result that we're asking for in this case, follows, pretty straightforward application of the decision in Carson versus Macon. So, our position has been that it's not really a difference in kind. It's, if anything, a difference in scope. And so, just to kind of flesh that out a little bit. So, not a difference in kind, meaning in Carson versus Bacon, there was, as a result of parents and kids not having a public school in their geographic area, they could get tuition funding to go to a private school of their choice. But what the state said was, except for religious private schools. So secular private schools are fine, but not religious private schools. And the argument made there was, you can't have a neutral and generally available program that applies to everyone, but say everyone except for religious schools can get this funding. And so the result of the decision in that case was that, yes, that is a free exercise violation of these parents and these students' rights. If you're denying them funding to go to the school of their choice just because that school is religious, just because they are religious. So those individuals, families, students were able to get that tuition funding to go to those schools. So in those cases, you might have 2 or 3 students wanting to go to a private religious school, and getting the tuition funding from public dollars. In this case, the differences aren't really all that great, other than you have more students. So here, this is a virtual charter school, so it's completely voluntary to attend. So no one is ever going to be required to attend a charter school in Oklahoma. I mean, that's the way the charter school systems are set up across the country, right? There's never compulsory attendance at these schools. So it's always parents' choice to send their kids to these charter schools. So every student who attends St. Isidore, a parent has decided, I want to send my kids to this school. And then all the funding that's at issue in this case that the school was going to be getting from the government is on a per pupil basis. So the state funding is based on the number of students whose parents decide to send them there. So whereas in Carson versus Macon, you have 2 or 3 students who are being fully funded by the state, their tuition being paid for to go to the school they want to go to. Here, it's all the students at the school who have their tuition being fully funded by the state. But again, that's not a difference in kind. That's just a difference in like the number of students attending the school that are getting the government funding. So we think the result that we're seeking follows pretty straightforward from the decision in Carson. If you want to dig a little deeper into that, I will flag one thing that the other side has argued, just so we make sure that we're being fair to the arguments on the other side. So there's a line in Carson versus Macon where the Chief Justice says that, of course, Maine is still free to make sure that its public schools remain secular. But then the court goes on to say that when the state decides, not to run its own public schools, so for example, to fund students to attend private schools in that case, then it can't discriminate against schools based on whether or not they're religious. So the Attorney General in our case has tried to use that line, the first line about the state can have its own secular schools, to say, the state can compel all schools that qualify as public schools in the state to remain secular based on that line. And that's when that distinction between government entities or state actors and private entities, private actors really comes into play. Because our position has been, we think it's borne out by the law and by the facts on the ground, that charter schools in Oklahoma are not being run by the government. They're not owned by the government. They're not started by the government, right? This is a private entity that went to the state and said, we want to run a charter school. So we're applying for funding to run this charter school. They select their own board of directors. They make all their own operating decisions. They have a lot of autonomy over their curriculum. So this is not about the state's ability to keep its public schools secular. It's about the state not discriminating against private entities when it allows private entities to run their own charter schools.
Right. Yeah, there's a lot there. That's really helpful. But I think especially your point is a strong one for encouraging the analogy of following Carson, and that I didn't realize that the way the funding structure is that it's per pupil. So I think that makes it just so much more similar to the funding structure and the situation of Carson v. Macon, because it's not if that wasn't the case, then you could have the argument that, well, even if nobody goes to this, or right, you're giving government money to a religious school. But you're right, this is again a parent's choice, and that directly affects the funding. That's really helpful to understand.
Yep.
Um, Now, before we wrap up, I want to ask a couple of practical questions. I know we don't want to try to predict the future. It's always dangerous, especially watching like oral argument questions or trying to play political with the justices and where they stand on stuff.
Right.
But in this one in particular, we do have the unusual situation that Justice Barrett recused herself from this case for personal reasons. So now to get a precedential win here, you need 5 out of 8 instead of 5 out of 9, which again means you need the generally quote unquote conservative justices, and that needs to include the chief justice to get 5, right? So again, I'm not looking for a prediction, but do you think there's any chance that this might affect the scope of the ruling? Any idea of how this changes the equation at all?
Yeah, so I'll start with the caveat that you led off with, which I always like to quote Yogi Berra here, which is, I try really hard not to make predictions, especially about the future. And so I'll avoid doing that. However, that being said, you always prefer to be the petitioner when you're in the Supreme Court, because the Supreme Court more often than not takes cases to reverse than to affirm. I think it's like a 60-40 or 65-35 rate reversal. So if you're the side that's appealing, it's a pretty good sign that they decided to grant cert to hear the case and decide the case. We also know that Justice Barrett decided to recuse herself before the decision to grant certiorari was made in this case. So the 4 justices that decided to grant cert made that decision knowing that they were going to be without one of the justices to decide the case. So given kind of that context, we were very encouraged by the decision to grant our petition. So just going into the argument, we felt pretty good about that. We also feel very good about the arguments that we're making. And if you think about the Chief Justice and where he might sit on this case, and he was probably the justice of the 5 Republican appointees. He's probably the one who was the quietest of the 5. Justice Kavanaugh came out very strongly in condemning the kind of rank discrimination against religion that he saw on the record coming from the Attorney General who sued our client over this decision to approve this Catholic charter school. But the Chief Justice was a bit quieter, as he often is in oral argument. But if you think back to the case law that we're relying on here, we're relying on Trinity Lutheran, Espinoza, and Carson versus Macon primarily. So 3 decisions that were authored by the Chief Justice, and then also relying on Fulton versus the City of Philadelphia, the case involving Catholic Social Services providing adoption and foster care services there in the City of Philadelphia, acting as a private contractor, doing work supported by government funding in an area that the government, at least for a number of decades, has claimed, this is primarily government space, doing adoption and doing foster care. So we were encouraged by the fact that not only has he written those opinions, so obviously we know where he stands on those issues, but he also asked the parties about the Fulton decision and what a ruling in favor of the Attorney General in our case would mean for private contractors across the board. So not just private groups that want to run schools, but if you think about Catholic Social Services and the Fulton case that wants to do adoption and foster care. If you think about religious hospitals, religious homeless shelters, etc. If the argument is, if what they're doing is something that government also does a lot of and tends to do the majority of, then that suddenly makes that entity a government entity that loses all of its constitutional rights. That could have really bad implications across the board for how public and social services are provided to the community and how religious groups are able to exercise their faith and serve their communities. So when we heard those questions from the Chief Justice at oral argument, that was also something we considered to be very encouraging sign. So we came out of the argument not making predictions, but certainly feeling a lot better being us as opposed to being the other side.
Yeah, that's a great point. I hadn't thought of the fact that not only did he sign on those, but the Chief Justice wrote both Fulton and Carson v. Macon. That's an interesting little fact as we await the decision.
Right.
So before we wrap up, I'd love just a short summary of what you think a best case scenario ruling, what kind of precedents we get out of this case, and then if there's a more limited in scope, narrower ruling, what that might look like.
Sure. So, we think the best case scenario ruling is a ruling that says, these charter schools that are run by private entities and controlled by private entities and given a lot of autonomy by the state, that these charter schools are not part of the government, they're not government entities, and they're also not engaged in state action. So they have they retain their private constitutional rights, whether they're religious or non-religious. So non-religious charter schools retain First Amendment free speech rights, for example. If they're a private entity, they bring all of their constitutional rights to the table with them when they run their charter schools. We think that ruling across the board would be a big win for religious and non-religious charter schools, because it would secure that autonomy and freedom that they've been given to continue to run schools that across the country are thriving and really serving kids really well. Related to the religious freedom question in particular, a ruling in our favor would say that, if a school is run by a private entity, so not a state actor or engaged in state action, then that entity has free exercise rights, and because of that, you cannot say that religious charter schools need not apply, that religious charter schools are barred at the door. Currently, there are 46 states plus the District of Columbia that have charter school programs in place, and they all run various aspects of those programs a little bit differently, but what all of them have said thus far is that charter schools are not allowed to be religious. Now, we think a lot of those schools, those states maybe made that decision based on an improper understanding of the Establishment Clause, based on the Lemon case we talked earlier. So some of those states may very well wish that they could open up their programs to religious schools, but just haven't thought that they could. So ruling here would make clear that all of those programs have to accept religious charter schools on an equal basis as non-religious charter schools. If they're going to continue to allow private entities, private groups to run those charter schools. So we think that would be a huge boost to the charter school movement and would greatly expand educational freedom to parents and kids across the country who can't afford to send their kids to private schools and really need a way out of the failing public schools that they're in. So that's kind of the best case scenario that we see. You asked me to think about worst case scenario, and I always struggle with this question. It's the one question I flubbed in an oral argument was, what would happen if you lose here? And I remember thinking to myself, I haven't thought about that, Your Honor. And he said, well, you should always think about what happens if you lose. A ruling against us, it's hard to come up with a basis because the court would have to change its government entity case law or its state action case law. What the AG has basically said was, well, let's come up with a new definition for what counts as a public school. And then just if it meets this multi-part definition, then part of that is it has to be non-sectarian, it has to be non-religious. And so basically just a special constitutional rule for public schools. So that would probably be the worst case scenario, because it would mean that private groups that are religious could be excluded solely based on their religion. It would also mean a lot fewer options for parents and kids who need more educational options and aren't being served by the options that are currently available to them. So those are the main kind of potential outcomes that we're looking at.
Okay. Is there any kind of middle way? Is there any way that St. Isidore's wins but gets a narrower ruling than you're hoping for? Can you foresee anything like that, or you don't really think so?
Yeah, it's really hard to come up with a narrow win in this case. I could see states reacting the way that Maine has reacted in the Carson case, in the wake of that case, where states could say like, okay, well, we have to allow religious schools, but now we're going to impose all these additional burdens on religious schools and be really strict on you and basically try to drive you out of the program. So if states respond that way, then obviously that's something that will have to be litigated. And if they show that anti-religious animus in taking those actions, we think that those cases are not going to turn out well for them. But in terms of a narrow or broad win, it seems like the only options on the table are pretty broad. And so then it's just a question of how the states react in the wake of a ruling like that.
Yeah, that's great. And like you said, you might have fights in hostile states, but in the meantime, I'm so hopeful about this case, and I'm so glad for the good work you've been doing on it, because this opens up so many important avenues, right? This isn't just about First Amendment jurisprudence. This is real educational opportunities on the ground. I especially we've seen so much of the breakdown of public schools come to light in the last few years. So many people looking for options, especially who maybe can't afford private schools. This opens the door for creative, religious-friendly states to be supportive of more options. And I'm especially intrigued that St. Isidore's is a virtual charter school, because then you think as an aid to overwhelmed homeschoolers or people in rural areas who aren't that close to the cities or to schools. This could just do so much for educational freedom and for the good of individual families and children. So I'm really hopeful about this, and I'm so thankful for all you're doing here.
Yeah, no, we're equally hopeful, and to the folks that have worried, well, what if some of the hostile states say, well, we're just going to take our ball and go home and just close down our charter school program if we have to allow religious groups. I really believe that the success of the charter school movement across the country and in all the states that have tried it is going to make it really hard for those states to make that decision, because the reality is the people living in their states are already thriving and benefiting from their really robust charter school programs, and to say to those families, we're going to cut off our nose to spite our face, we just don't think would work in those states. And so the result instead is going to be that suddenly families have additional options that are on the table, additional schools that they can send their kids to, and yeah, the prospect of having more virtual charter schools than anyone in the state. If they say, that the public school is not serving my kids and I can't afford to send my kids to the private schools that are within driving distance, to give them a virtual school that is a high quality education and free and publicly funded, we think that's going to be a huge boost for families across Oklahoma, and potentially, depending on the result, across the nation.
Yeah, I'm particularly intrigued by that one because so my wife and I homeschool, and so obviously we pay taxes that support schools, and we don't really use any of the services. But one of the only things I could see using would be like a classical Christian kind of charter school opportunity that's virtual, where you could at least
Sure.
take advantage of some of. That's a really good resource for people who otherwise might not be using the resources offered by school sponsored government sponsored education. So yeah, I'm really interested to see where this goes.
Yeah, I think that's absolutely right. And I also, we're homeschooling our kids, and it's because even on an attorney's salary, and private tuition is very expensive. So to the folks say, isn't this wouldn't this offer just too much competition for the good private schools? Would it hurt the private schools? And the reality is, no. Like, my kids aren't eligible for the private schools just because we're just it's not cost effective, right? There are so many families across the country that would love to send their kids to these great private schools, but simply can't afford it, and they have no option other than a failing public school in their area. So this gives them a new high quality educational option that they can afford. I mean, those are the kids, those are the parents and families that would be served by a ruling in our favor in this case.
Yeah. Well, this was a great discussion. I mean, there's so much to be done here on the First Amendment jurisprudence, the legal precedent that can be set here, but also, like we've just talked about, the educational opportunity, the creativity that'll be allowed by a good result here. So we're hoping and praying that we get a good opinion coming down in the coming weeks. So, Chris, thank you so much for joining us and taking the time to help listeners understand more about this case and some of the issues around it.
Yeah, sure. I'm happy to do that. Thanks so much for having me, Frank.
And thank you to our listeners, as always, for joining us. We always appreciate having you here at the Napa Legal Podcast. If you enjoy the content we're putting out, as always, we'd appreciate it if you like, subscribe from wherever you're listening, and we will talk to you in the next episode. Thanks, and God bless you all.